Please, my lord, I'll be confined only, my lord, obviously to the question for which your lordships have assembled. Well, that is retrospectivity or prospectivity. My lord, my submissions are, my lord, following. Lord, A, Lord, India Cements have held the field since 35 years, my lord, and parties have bona fide, under the law applicable at the relevant point of time, adjusted their affairs accordingly.
Yes.
My lord, difficulty with the mineral sector is this, my lord. My lord, mineral is essentially used, my lord, in every core sector of the economy. It will have direct impact on the economy of the nation. We are not, my lord, on individuals or companies or individual states. My lord, core industrial sector, my lord, especially critical to infrastructure sector, my lord. Almost all industries, my lord, I'm sorry, directly or indirectly, are dependent on minerals. For example, my lord, for steel, you need iron ore. For aluminium, you need bauxite. For generation of electricity, my lord, almost 68% generation is through coal, which is again a mineral.
Yes.
Now, industries, whether it is public sector or private, cannot absorb, my lord, the sudden rise, my lord, of past years, my lord, itself. It will have to pass it on. Now, kindly, my lord, allow me to give an example of electricity. My lord, electricity, the coal had a particular price, my lord, which was priced at the prevailing law at the given point of time, based upon which the respective commissions have framed their tariff, based upon which the consumers have paid. Now, my lord, the serious question now would be, now, my lord, suppose the generating company or the distribution company or any company concerned with the generation or transmission of electricity using minerals were to pass on, my lord, this additional past burden, can it be passed on to new consumers? Because all old consumers, my lord, have gone. They have paid respective charges as per law. And, my lord, now we can't ask them to make the payment.
Yes.
My lord, the moment electricity is affected and the moment, my lord, the basic input like, my lord, bauxite or, my lord, iron ore, etc. is impacted, my lord, necessarily it will have a cascading effect. And the effect will be felt actually by the common man. Now, my lord, there are several domestic contracts entered into, several international contracts entered into based upon the law prevailing then. And every contracting party was justified. In choosing their commercial bargain based upon the law prevailing then. Lord, international contracts, national contracts, your lordships are aware, some of the contracts are such where one of the contracting party is always wanting a way out of, wriggling out of the contractual obligations. They will use this, my lord, that now an additional burden, now the financial have changed. And they will cite, my lord, if there is a provision, my lord, in the contract for change in law, they will cite it. If there is no such provision, they will not be able to cite it. They will find out some other way that now it's not commercially viable for us to continue with the contract. And would lead to multiplicity of, my lord, litigations, which we are unable to, my lord, comprehend at this juncture. My lord, commercial contracts and commercial treaties, domestically and internationally, would be impacted. My lord, in every industrial, I'm sorry, my lord. The burden would eventually go to the common man, whether directly or indirectly. He will be the person who will bear the burden because no industry can absorb this. For example, my lord, we made a rough estimate only for the public sector undertakings. This is rough and ready, my lord. It is still the process of calculation is going on, but the approximate demand which the only PSUs are expecting would be somewhere in the vicinity of 70,000 to 80,000 crore.
Now, Mr. Solicitor, what was the prevailing interim arrangement during the pendency of these matters broadly?
My lord, there are several categories of cases, my lord. In some cases, the state government, the High Court quashed the order respective of, my lord, legislation of the state government. Like Orissa, and there is no stay. And they have never raised any demand for 35 years. In some, Lord, there may be some, either, my lord, the law was upheld and your lordships may not have granted stay, so some have paid. Some may have paid under the interim order of the court. My lord, my difficulty, my lord, just I'll not name the PSU because this is also a listed company, my lord, in the stock exchange. But in one of the big public sector undertakings, the potential demand which we have calculated is 3 times the net worth of the company. But for obvious reasons, your lordships would know, my lord, I am not naming that PSU, but a Maharatna PSU, my lord, a good, sustaining, successful, and financially fully viable, ongoing public sector undertaking. This would be the position with many public sector undertakings, and perhaps, my lord, most of the industries, my lord, if they have to absorb.
Broadly speaking, just to understand your submission, your prefatory points you have understood, but now we have to go by also a nuanced approach on basis of what was the interim position for all these years. So as you said, some where the High Court has quashed the legislation and there's no stay granted by this court. There's no stay granted by this court.
I have a suggestion, my lord.
Some where the law was upheld and they have paid. Third, payment.
Only Bengal is the only example.
Bengal is the only example of? Right, case one.
My lord, what I am suggesting is, my lord, subject to appealing to your lordship's conscience, my lord, because this is ultimately, as your lordships have said, my lord, not a jurisdiction under 142, a part of the judicial statesmanship.
And
My lord, what I am suggesting is,
you're also conscious of the fact that the states do need revenue and funds.
no, certainly, my lord.
And also that, as Sister Nagarathn'a also mentioned in her judgment, where the levy was set aside, Parliament actually validated the levy. So that was also the intent of Parliament, that the states must have the money.
That was, my lord, in 90s. But we are, my lord, after 90s. My lord, what suggestion I am,
What was the suggestion?
the suggestion is, my lord, we may not go into the state-wise enactment and what happened.
Possible for us.
It's
to
not
get into
possible.
Case and that.
My lord, in some states, my lord, one or two states, the amount may have been paid because of the no interim order passed by your lordships to the respective state government. My lord, your lordships may consider neither the state may demand any further levy retrospectively, nor the private parties or PSUs who have paid would seek any refund of the money.
Just one second, let me just.
This balances equities on both sides.
Just, I'll just-
I'm sorry, my apologies to your lordship.
was suggesting there should be neither demand nor refund.
Not refund, yes, my lord,
So, in other words, what you are really saying is make the judgment prospective, subject to the condition that whatever has been paid will not be recovered.
will
Is that
not
what
be
it-
demanded as a refund by anyone, by the private parties who have paid.
It can't be refunded anyway because they have succeeded now. The states have succeeded. Therefore, but what you are saying, we get the point that no recoveries for the past. And at the
And
same
no-
time, whatever has been paid under the interim orders will rest where it has been paid. If it has been
Correct,
deposited,
correct,
it is
correct,
drawn
correct.
by the state. You got your point.
No, another, my lord, worrying factor would be this. Your lordships are aware in MMDRA, we had an amendment in 2015, where, lord, the regime of auctioning, my lord, came. While participating in the auction, the respective bidders also, my lord, calculated the price structure and the law prevailing at that point of time, and we genuinely apprehend several litigations on that front.
What you're saying is that, well, to bring finality and some certainty in industry, in the affairs of the nation, that we should really ensure that there is no further litigation and
Well, that's the respect.
therefore adopt a gold standard which will ensure that, well, for the from here on now, there was an uncertainty in the law for 35 years, subject to, of course, Kesharam, which operated. Of course, Kesharam didn't operate only in the context of West Bengal. This is a decision of the Supreme Court.
No, my lord, but
Particularly in the-
nonetheless, my lord, my learned friend will have to say something on that. Wants to say something. But my lord, India Cement is 7 judges. Kesharam is 5 judges. It did not and could not overrule.
That's
Ultimately,
They
the
construed it.
Lord,
They construed it.
yes, my lord, but
It's not that it was oblivious to Kesharam.
no, I'm not saying that.
That's
It
why
was not.
you-
It was cited.
The way
But
the
let's
judgment
not,
of
my
the
lord, go
majority
into-
has been crafted. We have not dealt with whether it was a typographical
Lord,
error. We went into the first principle.
My lord,
This is
even
what
if we
I-
go by Kesharam, 20 years, my lord, have passed by.
So we have to also be guided
Kesharam
by
is
the fact-
2004.
We have to also be guided by the fact that we have construed now the matter's first principle on first principle, and we have upheld eventually the conclusion of Kesharam.
But Kesharam is also 2004. So, my lord,
Okay.
when your lordships,
Anything more, Mr.
lord, when your lordship, my
So we
lords,
can just
have,
briefly now, we can
Lord,
briefly hear.
Lord, would your lordships consider being assisted with 2 judgments, my lord? I have cited some 50 judgments, my lord, in my note.
Tell us the citation. You don't have to read those.
My lord, my note contains, my
Just give
lord,
us those judgments.
no, my lord, note is circulated.
Yes, yes.
My lord, I'll just, my lord,
Page 12 of your compilation.
yes, my
Mine is one.
lord, one is synthetic chemicals,
Yes.
my lord, inter alia. My lord, these are the 2, my lord, I can immediately cite.
Synthetic-
1990, volume 1, SCC 109.
And
And 7 is Somaya Organics, my lord. That is, both are constitution bench. Yes. My lord, in my note, your lordships would find it at page.
I've given all the paragraphs of judgment, para 89.
My lord, my para is page 22 in, my lord, synthetics chemicals. I have quoted the relevant para.
para is 89.
Yes. Which is quoted by, in my compilation at
Somaya?
page 22.
Somaya citation.
Somaya is 2001, 5 SCC 519. Lord, synthetics is 7 judge bench. Somaya is 5 judge bench.
Para.
And There, my lord, page 51, 59, 259, I have quoted, my lord, all the relevant paras. Para 27.
All right, we got it. We are well set with
And
principle.
when
Yeah, I-
2 to 27, my lord, I'll
Let me look at now,
Yes, itself said perspective.
India Cement,
Itself said perspective.
Yes.
Yes, cement itself will not 35 years
Ah.
ago, realizing the issue of demand will create lot of iniquity. Itself said perspective, it was immediately followed
it
without.
would have, my lord, not only domestic but international economic impact, my lord, on the country.
I'll take 5 minutes.
Just one second, let the attorney have his.
I have made note into 2M.
But broadly, I think the solicitor, we don't
All
have to start going now into
endorsement,
notes at this
all
stage.
endorsement
We
on
just,
that.
you can tell us
And,
what the broad issue was, and we hear the other side.
What is it, the multipolar impact on many, multipolar impact.
Multipolar impact.
So there is several things which are not visible before the court. So if mines and minerals are the spinal cord of economy today, there are many legislations which would have happened later, many arrangements made later. So in the interim, so many things which would have happened, which did not come into the reckoning of the court for good reasons while the court went into entries. Therefore, I think that will be an important factor because if the mining sector is impacted, the entire economy is impacted. From nanotechnology to healthcare. I mean, it's like that. And in my note, just only 2 paragraphs, lots will just make a look at it. It's in volume 2M. Paragraphs 2, 3, 4, and 5.
Mr. Attorney General, on a lighter side, I have not done what I should have done. It just struck me. Ever since you took over as AG, I should have maintained a little booklet of your aphorisms. Multipolar impact is what I have now got from nanotechnology to healthcare.
Yes.
Lord, the latest judgment is your worship, the Chief Justice's judgment yesterday.
Judges do maintain their own little dice.
Itself said, in perspective, yesterday's judgment in the Bar Council case, Lord. I read it in the paper today. I have
Bar
to
council cases, even marginalized.
say. I'm only saying,
Not the-
the lordships have said yesterday in respect of some other case, which is far.
Lord, right from
further
Kupalan till
than this
date.
case.
Lord, the word which catch my attention was that this is a 142 jurisdiction conferred upon the highest court of the country only,
Seni has also made his point.
It's only 5 minutes.
and only a minute. And the test is the judicial statesmanship. When you know that economy will be impacted.
After the solicitor and attorney,
I just
anybody
take
else
3 or
would
4
like to
minutes.
go now?
Yes.
Go
Kindly turn to
ahead.
page 182, just keep that open, easier and faster of the submission.
Okay.
I won't read, Wallace, I won't read. 182 has all the quotations. Well, his first point is we fully endorse the Solicitor General's comments, Wallace, his observation. Second is, Wallace, that my submission is your Lordship will not make it state specific, nation specific. Your Lordship is deciding prospective overruling or not. The acts will fall on this side or that side, subject of course to no refunds and no claims. That's a fair thing. Now, Wallace, what I've done is perhaps stating the obvious, but giving it some judgments which state the obvious. Your Lordships have held repeatedly, Wallace. First thing is, Wallace, that this India Cement, not only India Cement, but 5 judgments of the Lordships. First is India Cement itself, para 35, 36. Prospective overruling in the mining area. Second is synthetics, already mentioned, para 89. These are, Wallace, in my note, which is in your bunch, Wallace, at page 184 onwards.
All right.
182 onwards. Third is, Wallace, Belsund. These judgments are the same, Wallace. No refund, no recovery. Belsund, Wallace. Sugar is, all the constitution benches, 7 judges, etc. Wallace. In para Belsund, Wallace, 112 and 113.
Give us a citation of Wilson.
Yes, please. Belsund is 1999, 9 SCC 620. And the relevant paras are 112 and 113, Constitution Bench.
All right.
Synthetics, my lord knows, is 89 para number.
That is given.
Yes, and India Cements is 35, 36.
Yes.
Then, Wallace, a interesting judgment is Somaiya Organics, Constitution Bench.
Given us the citation also.
Yes.
And you got the para.
2001.
The 5 SCC 511, para 27.
519, Wallace.
51.
Para 27.
22 to 27.
Yeah, but Wallace, the crux, I've underlined it, para 27. Now, Wallace, in commercial matters, just keeping in mind that your lordships have innumerable high courts and tribunals in the country following India Cements for 35 years. In a much lesser context, the hiatus between Bhatia and Balco in the arbitration field, which was only about 5 or 7 years. 10 years? 10 years.
8 years.
In that context, fellows, in para 197, the citation of Balco is 2012, 9 SCC 552, a constitution bench.
All right,
Made it more prospective than even asked for. It said arbitration agreements entered into after this date.
fair enough. Anybody else, Mr. Datta?
Malad, I just wanted to add something.
Give a note.
Malad, I wanted to add something, and I promise not to cite any judgments.
Yes. Mr. Datta, can we just get back?
I'll be-
Sorry. Yes, Mr. Sarma.
As we always say, sometimes, Malad, certainty in the law is more important than purity. The reason is, Malad, people plan their affairs. Just to add to the width of the canvas of where this judgment will operate, Malad, I'm not for a moment suggesting that anything other than what the solicitor has suggested, i.e., no payments, no recoveries, and no refunds. So the situation as prevails today will prevail. Just to underscore the need for this kind of an order, I want to give your lordship an example. One of the petitioners before your lordship is Mahanadi coals. Mahanadi, my lord, the history is these lands were acquired by the center from the states. These are coal-bearing lands. These lands were acquired, they were challenged. The Supreme Court upheld the acquisition of land in the 1950s. And then the problem arose. The government said, you are not paying us anything. You've taken away our coal. So a payment is fixed under the law in lieu of royalty. Now, this is a complex arrangement between the state and the union of how this mineral wealth is to be shared. Then, my lord, in 2004, Orissa government came with the law. The High Court, following India Cement, struck it down. Whether it should or should not have struck it down, whether it should have followed Kesoram is another story. But the fact is, it relied on India Cement and struck down the law. And today, my lord, if this company is asked to pay, it is talking in excess of about 56,000 crores to this one company. These are, my lord, national companies. They have sold their coal to power generating companies, the power generating companies, that the solicitor has told your lordship, my lord. Sold water into the breach now. So if this company and this company, the other consequence which concerns, which must concern the court is, in some of these companies, the demand will be multiple times their net worth. The bankruptcy law doesn't apply. These are public sector undertakings. You will have the ugly spectacle of these companies just going belly up. If the governments insist they attach their properties, the companies won't be able to pay salaries. They will not.
That point has been made by the solicitor. Thank you, Mr.
So,
Anything else?
this is only to paint the canvas, how wide the canvas is. And that is why, my lord, certainty
Mr.
is more important.
Yes, just 2 minutes, Manoj. I made a note and taking the cue from Justice Roy, I've given 8 reasons why it should be prospective, Manoj. Yes. Yes. Manoj, most important thing is, Manoj, this Lordship has a nuanced approach. I've got a paper by the Ministry of Mines, which said in the aftermath of India Cements, several states lost substantial revenues. And then in 1991-92, the central government steeply increased the Section 9 royalty and the dead rent to compensate the states for the loss of revenue they would have suffered because of India Cements. So from the beginning, the royalties have been substantially increased. And Lordship knows that if even today, my lord, when I pay Section 9 royalty in Tamil Nadu, I pay into the state treasury. It's a levy by the center, it goes straight to the state. So I've given that Ministry of Mines report also, where the central government was compelled to steeply increase Section 9 and Section 9A levies to compensate the states for the loss of revenue. Secondly, my lord, I've given in my chart just 10 cases, right from 11 judges, Golaknath to Indra Sani to everywhere. every time there's a tectonic shift in the law, or the court is upsetting a provision which is based for 20, 30 years, whether Golaknath or Indra Sani or synthetics and chemicals, I have given 10 judgments covering constitutional law, mining law, arbitration law, tax law. So the uniform practice is there, and Golaknath, Justice Subbarao puts it beautifully. He says your lordship sitting in a bench of 9 lays down the law, but you make that law applied for the future because you want to ensure a smooth transition so that past transactions are not affected. Lordship, I've given the note first, para 49. It's a very nice paragraph by Justice Subbarao. He discusses the entire law in the US, how prospective, map versus Ohio and Linklet, etc. The sunburst doctrine. Yes. So that's the point. The other point I wanted to mention is one important point now. I read the judgment in detail. For the first time, my lord, I think there is a comprehensive discussion on the interplay between entries in list 1, that is 2354, and entries 49, 50, 54 in list 2 for the first time.
I've given you enough material for your new edition of the constitutional law book.
But in fact, on a serious note, I just told him we have to rework entire Schedule 7 now. Thanks to your lordships.
Lighter way, if 9 judges partially modified 7 constitutional benches and 7 judge benches.
Mr. Datta wrote a letter to me seeking to be recused from the Senior Advocates Designation Committee. He frankly said that with my book coming up, I have no time for anything else. So I think with this judgment, you might have to extend that sojourn away from the court for a little longer.
You'll have to postpone the public. So, my lord, yes, I'm grateful, my lord. But on a serious note, lordship has really, my lord, considered the interplay of various things. My lord's just dissenting opinion also. Now, most important thing is, these laws were held to be legislatively incompetent. India Cement said states have no competence. Now your lordships are restoring competence for the first time in 2024. So from 1990 to 2024, and with great respect, my lord, Kesoram may, whatever it does, Kesoram cannot override India Cement. That way to be very, very clear. We should not send a wrong message that tomorrow a 9-judge bench, a bench of 4 will say, no, there's some mistake, I'm nuancing it, and that applies. 7 is 7, it has to be followed. Tamil Nadu, they followed, didn't make any new law. My lord, Sundaramaya's case is important now, my lord.
Yes.
My lord, the Orissa Act is 2005, Jharkhand was struck down, West Bengal was partly upheld, etc. Now, in Sundaramaya's case, they say, if a law is struck down for legislative competence, it does not revive. He makes 2 distinctions, law struck down for constitutional prohibition and law struck down for legislative competence. And Justice Venkatramaiah says that if it is struck down for legislative competence, it will not revive, it has to be reenacted. So that's the reason why it has to be prospect. Now states will necessarily, because the 2005 law was based on India Cements and other laws. Now your lordship judgment holds the field. It's very important. Your lordship has completely redesigned the constitutional topography of all these entries, how to interplay both and so on and so forth. So I'm only submitting in light of Sundaramaya, it will be prudent for the states now to make a fresh law keeping in mind these.
That's their choice.
That's their job. But I'm only saying that we have to be conscious of that fact. That's all.
That is on
and the
the principle.
One thing I want to say.
If a law is,
Right,
if a law is struck down judicially on the judicial side, and it cannot be revived judicially
Yes.
by another order.
Yes.
What has been struck down, it goes as void.
That is what.
It's more academic than practical.
Take another
So
judgment.
we will not express any views,
No, no.
because that's exactly the point in the Article 39B and C.
Yes.
Exactly, my lord. Therefore, my lord, I was also avoiding that argument.
Yeah.
Lord, that's more an academic argument in this matter for this limited purpose, my lord.
That
And
issue, my lord, is in that Bombay Rentec matter, which your lordships are now going to
Which
decide.
we have reserved.
Yeah,
that.
and
Yes,
Yeah,
which
yes.
you decide. But this judgment holds, my lord, that what is dead and buried on account of legislative competence not being there cannot be revived, and therefore will have to be a fresh legislation. If it has to be fresh, it has to be today, after the lordship
We
judgment.
did not go into it.
but that's not the issue right now. That's
Also,
not the issue. Right?
and that's the precise point on which we are reserved
The
judgment.
lordships have reserved the judgment. Sir, we have assisted for a
Considering
long.
Article 31C, etc.
And-
Only one thing I want to add, my lord.
Yes,
Only one thing. I want to add.
for future generational lawyers, yes, okay.
My lord, only one thing as a matter of Lord, as a,
That's okay as a point also.
yes,
We are saying that let us preserve something for future generation of lawyers.
So, all right, let's
But
hear
the-
now.
only one line your lordship may note.
Lord, the last
Lord, the
point.
Odisha Act was enacted on 1/2/2005. Just note that date. Odisha Act, my lord, was enacted and became operative on 1/2/2005. It was struck down, my lord, on 5th
Not
of
go
December.
statewise. Let's not go statewise.
I don't want.
Yeah.
On
It-
5th
it-
of December
it go where?
2005.
It go-
So it lived for 6-7 months. There were no demands. There were no demands under that law. And, my lord, it was declared unconstitutional, which is now being sought to be revived. Now, this is Odisha's position. Some states' position may be, my lord, hybrid, some way, midway, etc. Therefore, it is best not to go, my lord, into this situation, because some state will say, why we were, my lord, placed in a position where some money was paid, somebody will say less money was paid, somebody will want a refund. So let's not, my lord, apply this principle. The lordship judgment is for the whole country. Therefore,
Are there any interim orders requiring a deposit plus a security for the balance?
not for Odisha,
Not-
there are in one or two cases, there is an order of deposit of some part. Yes.
All right, let's hear.
Only
the-
one
Lord,
line, my
the
lord.
last
Academically, my lord, only one line, my lord. I have compiled
The reason for, I'm only requesting, the lordship can subject to all lordship's approval. This is the problem we constantly face. A 5 judgment declares a law unconstitutional or uphold, but there is no direction it will be prospered or not. I'm saying on an important case, like for example, lordship, that arbitration matter on stamp duty. Lordship set right a law, that necessarily has to go back. Because lordship, you're curing a problem, but if lordship is completely rewriting the law.
All right, let's hear.
Lord, only one line, my lord. Only one line.
Danger of retrospectivism, the past becomes uncertain, which is not conducive to rule
All
of.
right, we'll-
Lord, only one line. Lord, we have compiled 63 judgments where your lordships have consistently applied, my lord, the doctrine of prospective overruling, which is annexure A to my note, which is already filed and circulated.
Let's see.
I have given
Lord,
extracts of 10 judgments in annexure A.
the-
Lordship, with the paragraph number, with the extract. So lordship just sees my, with annexure A. So lordship need not go through all the book.
Yes,
Deeply aware.
yes, Mr. Dutta.
I think the advocate, learned advocate general of Odisha wants to say something before I.
Certainly.
We have a very
One
specific.
second. Just give me 1 second. Yes.
Yes. That as your lordship knows, this Odisha Act is basically in tune with the social welfare measures. And Odisha's population, mostly these mining bearing areas, are scheduled tribes because we have 9 districts as the scheduled areas. So the socio-economic development of the state was of paramount consideration, for which this 2004 enactment was made by the legislature. So the rule was framed in 2005. I have a very specific stand. I have prepared a small, these are the notes which I may pass on in course of the day. Mrs. MISRA will pass over. That this, while implementing the provisions of the rule, we have to keep in mind certain subsequent developments by way of legislation, 2015 amendment, some ad valorem royalty.
Advocate General, in Orissa, the act was brought into force with effect from 1/2/2005.
That is correct.
That is correct.
That is correct. That
And
was
it was
the,
struck down on 5/12/2005. Is that correct?
right, absolutely. correct.
Now, what has happened after 5/12/2005?
No, because there was, after the legislation was struck down,
Be collected because it was struck down.
that's, it
And
was struck down.
following India Cement.
Right. So after that, because there was no interim order here, so we could not proceed further. So it is as it is. So, but now subsequent laws have been enacted because this MMDR Act Amendment 2015, some royalty says imposed. These are the 4, 5 bullet points which I have been instructed to submit. So while implementing this rule, 2005 rule, we have to keep certain subsequent developments in mind, like introduction of ad valorem rate of royalty since 13th of August 2009.
Right now arise.
So
Valorum,
this is they have said, so I have to introduction of auction for allocation because 15
ad valorem royalty with effect from?
royalties since 13th August 2009.
Yes, and second?
So second is introduction of auction for allocation of the mines, that is by 2015 amendment. And this is auction premium is an additional payment also. The third is introduction of provision for collection of the DMF, District Mineral Fund. That is also basically meant for the taking of the social welfare measures.
Look, these are collections over and above section 9. Malod. So
That's correct.
we are not really concerned with this. Malod.
So
Therefore, the
these-
Advocate General is rightly sitting in the middle, not on this side.
But if we go state-wise on the lighter side, state-wise, Lord, state-wise, Madhya Pradesh and Rajasthan, I had a talk with their councils. They say that we have taken a pro-citizen approach. They are also supporting the prospective overruling.
All right, let us see that.
But that hardly, my lord,
All right, let.
So now at this juncture, you will have
That's
to
the
know
third,
the
that
state
district
economy
mineral
is
fund
bleeding.
payment. Then that's the third. Anything more on
And
that?
the fourth is introduction of provision for collection of payment of national mineral exploration trusts. Because these are the two funds which will be basically, the corpus would be utilized for the benefaction of
Now
the.
tell us, do you have an estimate in Orissa? How much did you realize in
That-
excess
that we
as a
have not
result of ad valorem royalty? Then as a result of the additional premium which was liable to pay it for after 2015, then the DMF and the National Mineral Exploration Test. Do you
That I have to work out
financials
because
on
that
which
data,
can bear in?
that calculation is not yet made because I have to seek further instruction for that. So, but, the legislation was basically meant for that, for the socio-economic development of the rural sections of the society, basically the scheduled areas I pointed out. So these are the four specific,
So what is the position then of the state of Orissa that the judgment should apply on its all fours without being made prospective? What is the bottom line?
that's
sir?
correct, that's correct. The bottom line is we have to precisely work out what would be the total implication because the rule is to be.
You're not supporting the plea for prospective, the prospective
So
application.
if I say prospective, it would be a burden on our exchequer. Exchequer would be losing substantially. So basically, the economy of the state is in shambles now. We have several commitments for the
No, wait.
socio-economic development.
of Honorable Chief Justice is, what are the instructions about the correct stand you should be taking before the court?
So
On this side or that
correct
side?
stand, exactly, they have not specified here. So
You have
this is
you
the
have to-
stand I have
As
to
the
work
state of
out.
Orissa, you have to
Because I
lay bare
did
your,
have-
you have to lay bare your
So
stand.
actually, frankly speaking,
Because your first 4 points which you referred to indicates that, well, we've realized something more thanks to the amendment. The second point, namely the 9 scheduled tribe districts, etc., seem to suggest that implement the judgment as it stands. Don't.
that's correct.
So now within these two, where do you really,
No,
you've
we-
placed before us both the submissions, one on this side, one on this side.
That-
Which is the
No.
submission which you are now adopting as a state?
That actually,
Don't pass on your dilemma to the court.
right, it's not exactly,
You have to take
I have,
we will decide what to do ultimately. We'll hold the balance, but you have to tell us where you stand.
and I have to first, because this judgment is epoch making. Now it has cascading effects everywhere. The learned Solicitor General also submitted. So I am not going into that in detail for the time being.
No, but
But
are
the
you
question
supporting that or you're not supporting? You have to tell us. Now that you are appearing, we'll hold you down to a.
Now the scenario has changed in Orissa, your lordship knows. There can be contradictory stands. So, but the
So
question is,
you therefore.
No, this
you
is not
therefore-
the way.
Therefore, flowing with the
So I have-
Solicitor General, are you?
that I have to protect my exchequer, whatever, maybe because we have some.
No, if everyone is protecting everyone's exchequer. The question is whether windfall, which is ultimately being shared by the common man, should be acceptable or not. That's all.
But But a common man should not made to suffer because of.
Thank you, Mr.
I'll pass on a note. That these
Uh,
put 5
you-
points.
anything?
No, just wanted your lordship had put a question to the learned advocate general. What is the royalty received by the state government? Lord, as just
That we have to work out. We have not.
26,000 have been paid.
That we can say now because I have hardly put in 3-4 days back, I assumed office, so we have not worked out also on that so far. To state mein na, private budget mein.
A question to the learned advocate general as to what is the royalty paid? Just one company, that is Mahanadi Coalfields Limited, has paid in lieu of royalty because Mahanadi Coalfields doesn't pay royalty. These are all acquired lands in lieu of royalty from 2005 to 2006 to 2022 to 2023 is 26,141.63 crores.
Just one company.
Just one company.
But they'll not seek refund, that's all.
Refund, this is raw, in lieu of royalty.
But that's okay.
No, there's no question of refund. This is because we don't pay royalty.
The money, that's all.
This is over and above section 9 and 9.
This is not that way.
No, sorry, Mr. Datta, 9 is not paid. This is in lieu of 9.
Yes.
Yes. So that I want the judgment to operate fully. And I'm against, my lord, any declaration of prospective overruling. I'm not against the authority of this court, my lord, to direct prospective overruling. Golaknath and onwards, my lord, there are numerous judgments, as the learned counsels say, my lord, where the power of this court to make its own declaration in view of change of law, prospective, that's not being disputed. Issue is when it should be made prospective and when the court should not make it prospective. Or even while making a decision for molding of relief, it's not necessary at all to make a declaration of prospective overruling. The lordships can let the judgment flow with full effect and at the same time impose certain conditionalities based on which the judgment or the declarations of law would follow. The second, my lord, in the instant case is a more appropriate course of action. Now, all these judgments, India Cement, Odisha Cement, Somaya, Synthetics, etc. They are right, there are about several dozen cases. They are in the context of a change of law which results in the enactment being declared ultra virus. In synthetics, the change of law, that is the overruling of the judgment in HRS Murthy's case after 15 years of operation would have led to the states refunding the entire collections, which over the course of years the states spent in exercise of its sovereign powers. So therefore, these are those cases where they said that, all right, the law is rendered invalid because of our declaration, but we are imposing a condition. The judgment will operate retrospectively, but there will be no collection, no refund. So this no collection, no refund, which my learned friends on the right are clamoring for, that is all in cases where the new declaration resulted in the declaration of the operation of the law is ultra virus. There is no judgment of this court where the change of law results in the validation of the act, Taxation Act, and yet this court says don't collect. There is one judgment of 9 judges judgment, my lord, where my lord, the Chief Justice was a party. That is in Jindal Steels. Entry tax. Kindly recollect, my lord, judgments 50-year-old were overruled. Atyabari, Khairbari, automobile, all were overruled. But the declaration was not made prospective. There is a rationale for why it was not done. And why likewise in Keshav, my lords, also it was not made prospective. There is a rationale behind it. The rationale is this, that if you make the law prospective, let's stay in the instant case, pure and simple prospective, nothing more. What would be the consequence? That either India Cement or Keshav needs to operate then. There can't be a vacuum in the past. So Lordship will have to decide, my lord, this 5, 7, etc. I would say, my lord, once your lordships have upheld the dictum of Keshav, then to say that India Cement will operate till yesterday would mean that all the laws passed by the states which are under challenge, including those which are founded on the pattern of the law upheld after West Bengal's law was upheld, then many states would have passed, just copied that pattern and enforced their laws. They all will have to stand the test of India Cement. Because your lordship's declaration is post facto. So the intention would be that judge our laws. Your lordships have yet not declared our laws valid or invalid.
So if we hold that our judgment is prospective, then really speaking, possibly could be argued that those laws are invalid.
Because India Cement comes in the way, it is struck down.
Until we delivered the judgment, the law was as it stood in India Cement then.
So now that would be a travesty of justice, not if I don't use the term absurdity. It will be a travesty of justice that the law is this today, but our laws are struck down because of India Cement.
Which law is my
Please,
just for
please,
our
back up, please.
understanding, which law?
Which law you will know?
There is no law.
Just hold on, which law? There is no law.
Giving the judgment prospective effect, therefore, will seriously impinge on the laws passed by the state legislature, which would otherwise be valid on the test which we have enunciated by the majority.
That's right. No, our law is of 1993. Jharkhand. I don't know.
1993.
Strike down Prabhu, strike down.
22nd March 1993.
It was on 22nd March 1999. In between, probably there was some interim orders or something. But I'm not on these interim orders, etc. The question is, if you make it pure and simple prospective, and only no refund and no collection, something which was in a contra situation directed, namely, even if we are suffering invalidity because of the new declaration, still no refund.
We make it prospective. Solicitor has not argued for prospectivity per se. Solicitor has argued on the second aspect, which you said that do that, that's a much better declaration.
With respect, no, solicitor says prospective, but no refund, no collection.
He said, and you are saying conditionalities is a much better option.
I'm saying, therefore, please don't go and use this term prospective.
Right. We got the point. Now, look at it this way. Another thing which you have pointed out, if we say prospective, then in any case, for the period prior to our judgment, you will have two decisions. You will have India Cement, which is of a larger bench, and you'll have Kesoram, which is of a smaller bench. Now, we have on first principle,
So for
we have
that, that's
adopted
why,
the Kesoram line.
that is why they say that India Cement is of 7 judges and 5 judges, and therefore India Cement should continue. Your Lordship will have to now, having rendered the judgment, now your Lordship will have to say, not Kesharam, India Cement will operate till today.
So we have expressly held that India
And
Cement.
that will be again, my lord. So we are entering into a whole lot of.
But Mr. We got the point, the jurisprudential thicket which will arise.
Yes.
But short of that, if we are to, because your second point was without prospective overruling, the court may impose conditionalities.
That's right, your lordships. It's a 142 lords is not a one toolbox.
We would like
It's a toolbox with many tools.
We'd like a little bit of assistance from your side without really conceding. You're appearing for the state of Jharkhand. You're not
Yes.
asking to, you're not going to record it as a concession, but we are now looking at you as an officer of the court. And
Yes.
person, standing who we look up to for your assistance, just as they have rendered assistance. What kind of conditionalities can the court contemplate?
I will not, notwithstanding the instructions not to concede, I told them
We are
that I will
asking
not.
Mr.
forward
Bedi, as
this.
we are putting you in a little bit of an embarrassment, but
No,
we
no,
realize
no
that.
embarrassment at all, my lords. It's a
Mr.
privilege
Bedi,
to be
as
an officer of the court.
is somebody who is assisting us on a fundamental issue of constitutional law.
No,
What-
no
what would you
embarrassment.
like?
No embarrassment, my lord. It's a privilege to be an address as an officer of the court, which we are always donning that hat, my lords. We never shed it. So now, my lords, there's another aspect. A lot of things have been said about the impact orally. There is no affidavit before a lordships of any of the barring sale, which has mentioned in its affidavit that there is some huge all over the states. So now they
But the event of death not standing.
at page 813 of Golaknath, lords, though overruled in Keshwanand Bharati, but this principle has not been overruled in Keshwanand Bharati. So it continues, lord, and has been used by this court as a tool. Whenever ends of justice require, lord, at page 813, some poignant observations. Court says it is really a pragmatic solution, reconciling the two conflicting doctrines, namely that a court finds law and that it does not make law. It finds law but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting its errors and without disturbing the impact of its errors on the past transactions. It is left to the discretion of the court to prescribe the limits of retrospectivity. So this is what I was relying upon to say. And in subsequently, lordships have said that there are so many variations. It's not a rigid doctrine. It has enormous flexibility, which is indicated by the phraseology of Article 142 itself, when combined with 141, 136, and 132. Then again at page 814.
Mr. Dwivedi, prima facie means subject to, of course, our considering the submission. No question of prospective overruling in a situation like this prima facie. I have not discussed with my learned colleague. We'll all sit down together and. But the question is that, as you rightly said, that even if we don't give prospective effect, you have to. The court does have the power to balance the conditionalities. What will happen for the past period? One, no refunds, where the states have collected. There can't be any refund now because we have upheld the power of the states. No question of refund. If we were to make it prospective, then the question would arise because, those laws would still be, somebody can argue those laws were invalid on the basis of India Cement.
India Cement
Therefore,
still
the states have
operates.
to refund. Once we have said that the states do have the power, there is no question of the states being required to refund. Question is about the new demand because for the past period. Because we can't be also oblivious of the fact that, from 1999, in your case, the law was struck down in 1999. There's been no demand, 24 years down the line. So should we contemplate a situation where 24 years later, there will be now demands on the companies, many of whom are public sector companies? That's something which we have to put to you. You may have
No, I appreciate, it's not that I'm unconscious of that, but the
law, India Cement, 7 judge, Kesaram 5 judge. With this particular judgment of the 9 judges, a clarity on the law is laid down. You are trying to say that it should have effect retrospectively, but you are referring to Golaknath saying that a pragmatic view is to be taken. Now, the concern that is being raised by the other side is on the financial implication if either of the view is taken.
Yes.
Now, we have to be a little conscious of the financial implications, not only financial implications, the commercial contracts, covenants that have been entered, domestic or international. Now, a lot of those disturbances are likely to happen. And of course, the financial implications are also going to be of considerable.
So, if your lordship
will have to assist us in the way of conditional implementation. Conditionality, as you have said.
So, my lord effort is to request that your lordship balance the two, my lords. Not if you look at simply, my lord, the cascading effects, the huge amount to be paid, etc. There are other ways of balancing it. For example, if you have to pay 500 crores, let us say, assume, my lord, for illustration, that can be staggered. You pay arrears every annum, 50 crores. The next 10 years, it will be paid off. So this implication and huge burden, etc., is not something. One thing is to allow them to pocket it. Don't pay at all. The other is to stagger it. The better course is to stagger it as much as your lordship finds reasonable. 4 installments, 8 installments, which lightens the burden. Prevents the cascading effect. That's the only impact which they have voiced. Your lordship, second thing your lordships can do is that, for example, in our case, it's not a tax on minerals. We have imposed a tax at the rate of 1 rupee per square meter on the land. Whatever you may extract and sell, we have nothing to do. You have this much of lease land. On that land, we have imposed it, so it's a fixed per annum. And so far as sale is concerned, which has filed affidavit, the entire burden is about 454 crores. Now, what, Judge, please.
I'm sorry.
The maybe staggered, the demand may be staggered over 4
Just
or 8
allow me
years.
a little leeway, Manoj.
Would it be possible for the court to also prescribe conditionalities that only a certain proportion of the demand for the past period should be paid?
So I'm just providing some more, Lord. For example, now under our act, there are two kinds of lands, or rather three. One is mineral bearing land, the other is industrial land, and the third is commercial land. So it's not only mineral bearing land. Now sale out of 454, 430 is industrial land. It has nothing to do with India Cement, etc. Now why should not, therefore, if their whole basis is India Cement, why should the industrial land and the commercial land will not be given that benefit? This can only be limited to mineral bearing because India Cement was confined to cession royalty. So on their own submission, the conditionality should be limited only to mineral bearing land, even the staggering part. As far as the rest is concerned, under the Lordship's dictum, restitution is the normal principle. That if you have relying on an erroneous judgment of the High Court, you can't say that this court has.
In relation to land other than mineral bearing land, there's no case according
There's
to
no case according.
sale.
It has to be limited to mineral bearing land. The third thing is just.
Yes.
So there are only 6 mineral bearing land SSEs. 18 are industrial or commercial. They all want to ride on the shoulders of the mineral bearing land, India Cement. This controversy of 5-7 doesn't impact them. The third thing which can be done is under the Act and the rules, the rate of interest is 2% per mensum simple interest, which really comes down to 24% simple interest. So bulk of the demand, which they are saying 60,000, 70,000 is on the interest component. As usual, their demands are not that much, but since 20 years, 30 years have passed and their amounts were not paid, therefore that component will go up. That can be more suitably tackled.
No, are you correct? Is our understanding correct that the figures that have been cited by the other side has the element of interest added to it? And
Yes,
it is being
yes. Although I can't say none of them have filed affidavits. They are all just trotting figures. We don't know.
Interest is something which certainly the court can.
Yes, but in my submission, I have annexed the statements of each company. I have given the statement, interest also I have given. And the Lordship will see from that chart that the interest component is really for example, sale is 558 crores demand over this 30 years. But interest is about 1,000 crores or something. More than that. Now, so if that is suitably modulated, it will reduce their burden. So we are here for balancing. None of the petitioners have talked of balancing. No collection, no refund, ultra-virus cases. We are here in intra-virus situation. Normally, in view of Article 265, once a law is passed, nobody can say that don't collect the tax. But the Lordships have got this special powers under 142 to modulate depending upon a particular situation. Otherwise, ordinarily, your Lordship will never do this, not that the law is valid, but don't collect the tax. But let me take, my lord, my learned friends must have calculated, my lord, I'll take them on their words, my lord, so that I can also visualize that there will be some effect, maybe cascading. So this is how, my lord, it can be done. This is not, we need not adopt the ultra virus situation, my lord, here and say that no collection, no refund. That's very convenient because nowhere they must have paid. The proceedings must have.
Struck down soon after India Cement.
Because somewhere, even where your lordships have said no interim order rejected. I have an expert in my every case. Barring Odisha, Bihar and Jharkhand. In Andhra Pradesh, stay rejected. This is another vital factor. That once the stay was rejected and High Court you lost, then you should have collected, you should have passed on. If you have not passed on, then you have willingly not passed on. And the law on tax is that passing on is your discretion. Not a law.
What happened?
No, there was no law, my lord.
My lords, if I
There
may
was no
come-
demand, my lord. State-wise, we have to say many things.
Can be state-wise.
State act-wise, we have
Talked
to
about,
say
my lord,
many things, my lord.
mineral bearing land.
My lord-
Odisha is all mineral bearing. The act was struck down in 8 months. Not a single penny of demand was raised.
I don't understand.
You could not collect. I could not
My-
pass.
State has a different mechanism.
Situation, my lords, 2005, a cess was levied on minerals. My lords,
Yes.
while entertaining a challenge to the cess, the High Court declined to grant an interim stay. In 2007, this honorable court gives an interim stay on the operation of the cess. Till date, the act continues to be on the books. Therefore, my lords, in my humble submission, act which continues to be on the books, the question of prospectivity or retrospectivity would not arise. Only the operation has been stayed by an order of this honorable court.
Struck down in Andhra Pradesh.
Never. That is why we are on a factually unique footing, and I just want to point it out.
It was not struck down because the
Now-
matter is pending here.
Now,
My
Madhya
lords,
Pradesh-
yes,
just hold on.
We have to say much.
Now you say much, nobody stops. Please.
Jharkhand, can't apply.
No, don't.
But you are interrupting.
No, we have to see state-wise because
State-wise, my lord, we have to say much.
This-
The architecture of every act is different.
the Andhra
I
Pradesh
think
did
what,
not share
I think
because
what
of.
we should do is, we'll lay down broad conditionalities, that which is within our power. We'll of course reflect on it, but what Mr.
Well, I
Mr.
Just,
Dividi has
just
said-
allow me to finish.
Well, I want to say something after you conclude.
Let him finish.
Let
Let
Yes,
him-
yes, after you conclude.
Sir, let's not, 1 second, Mr. Divedi will finish in 2 minutes now. We let him,
positions of
Where-
process and we're not paying our.
yes, Mr. Divedi.
Now, Madhya Pradesh, my lord, High Court upholds, no stay. Rajasthan upheld, no stay. Chhattisgarh upheld, no stay. Chhattisgarh, they said you have to pay subject to the outcome.
Are these laws
No.
under entry 49 or under entry 50?
So there are many things. State-wise, we have to say many things. And Madhya Pradesh and Rajasthan have taken a pro-citizen-centric approach.
All
That
right,
we do
let's-
not wish to
Right.
collect the past dues.
Who prevents the states, my lord, from passing a law tomorrow and saying that don't pay? It's not my argument that if your lordship says it will operate as it is, then Rajasthan is certainly free, my lord, to pass a law and say
Or they'll
that we will
raise
not collect.
demand. Or they'll not raise demand. That's
Don't
it.
pay. If Odisha doesn't want to give a concession, it can certainly do it. So what is the problem in the states?
So Madhya Pradesh High Court upheld the law, no stay.
No
Rajasthan upheld the law, no stay. Chhattisgarh upheld the law.
UP, no stay.
Sorry?
UP, no stay.
Which law?
What's that law?
So the point is, what I'm saying is, West Bengal, Kesharam upheld, and right from 92, my lord, they have collected tax. All areas were paid fully. Heavens did not fall. No industry sunk. All these people are there in Bengal also. Why don't they produce their balance sheet, etc., to show, my lord, how much is that? 61,000 crore is the turnover of sale.
So Dwivedi, if we go into the states, it will be never-ending inquiry.
The architecture.
No, I'm not saying.
is different. My
point is
reasons
different.
for setting aside is
What are
different.
the provisions of those laws which are struggling?
I'm saying
Whether
something
they were
else.
under 49 or 50, that also, my lord, is an issue to be considered.
I'm not requesting your lordships to go individually into the acts, not at all. What I'm saying is that look at the discrimination which will happen. West Bengal collects, other states rejected. Now we say don't collect. Best course, therefore, in the circumstances of this differential situations, and your lordships in the 9 judges judgment have accepted fiscal federalism. So because of some state, etc., another state can't say. This richer state may say, we will not collect. A poorer state may say, we need the money. We are not able to pay the salaries and the pensions. SLP is pending in this court for paying of pensions, brothers. So ultimately, please balance. That's my bottom line, which I'm trying to convey is that please balance. It's not only their problem, it's a problem all around. So the proper balance, therefore, has to be, in my respectful submission. The first submission is that please stagger it, tackle the interest. That will reduce the burden drastically and make it comfortable to pay. So I'm not saying go into individual cases, but look at the situations. Some state collecting, another state, some has collected, other state could not collect because these differentials, therefore can't enter into the melting pot. Now, the other thing, is that supposing this doesn't find favor, then the other alternative which could be thought of is that right, wrong, whatever, whether it was proper or not, Kesharam made a change. Now, Kesharam basis, Bengal collected, other states make their laws, etc., which are under challenge and now likely to be upheld. Therefore, that can be another cutoff point. Plain and simple, do nothing and just this.
The date of Kesharam?
That is
15 January 2004.
2004.
15 January?
January 2004.
Years.
So which instead of 30 years or so, it will be 20 years.
India Cement is dated?
1990, volume 1 is
25th October,
1990.
25th October 1989.
So along with that cutoff date and something tackling the interest, that is a neat and clear. And then our judgments, acts will be tested on the basis of your lordship's judgment. That's my humble submission.
So really 3 benefits, according to 3 benefits. One, stagger the payment, so delete the interest, and take Kesharam as the cutoff.
It can be combined or alternatively. I would put it as I'm leaving it to your lordships.
Respective levies, commercial improvements.
You are appearing
Yeah, I'm appearing in the UP matter, my lord. Facts are very startling, my lord. In the UP, the High Court has upheld the levy on 1st of March 2000 in Ramdhani Singh. Matter is carried in appeal in Kesharam, and in Kesharam, judgment is upheld in paragraph 134 to 148. So, my lord, so far as UP is concerned, there is no question about it. My lord, the levy is valid since beginning. And my lord, the entire premise is based on that India Cement is holding the field till 24th of July 2000.
Did you raise demands and were they paid over to you? What is
My lord, 2 of the industries have come to your lordship. They filed a writ petition, my lord. Subsequently, they filed a transfer petition and matter remains pending. Only 2, Hindalco and Kanodia, my lord, has filed the transfer petitions.
But your levy was upheld by the High Court?
Upheld by the High Court
In Kesharam.
and Supreme Court specifically deals with it and upheld it.
So have
My lord, we have collected,
on Hindalco and the other.
and
industries,
yes, my lord,
you would have
Kindal
collected the money.
and Kanodia Chemicals are the two persons who have been holding it, my lord. All others must have paid. So where is the question of two industries, my lord, because they choose to file a transfer petition, get a, my lord, interim order there, ex parte, file a transfer petition, High Court proceedings remain pending, and they, my lord, they don't, and we, who says, my lord, they have not collected, not passed on, there are no facts, my lord. 142 is very important, my lord, what your lordship has said in 142. My lord, what your lords, what your, I'm so sorry. Yes. Lordship says 142, my lord, Lordship would balance the equities to do complete justice in a cause or matter pending before it. They must plead and prove, my lord. A bold statement. My lord, one more thing, Lord. The entire premise is based on that India Cement is holding the field. My lord, India Cement is not holding the field, my lord, since 15 January 2004. Please. 15 January 2004, Kesoram is holding the field, my lord. Last 20 years, my lord, right, wrong, your lordship has decided. But what is holding the field is not India Cement. What is holding the field is Kesoram, my lord, from 2004. And my lord, finally, one more thing, my lord. Courts have said, my lord, Blackstone famous dictum that court finds the law and does not make it, upholding Goloknath. Retrospectivity is the rule, my lord. And my lord, prospectivity is only an exception. They must make out a case on exception, my lord. Please, Lord.
The predicament and my privilege for the state, my lords, for the state of Jharkhand, and I have not made submissions on the last occasion, my lords, because everything.
Mr. Dwivedi argued for Jharkhand.
Mr. Dwivedi is arguing.
He has appeared for the appellant, that is an authority created by me. I just wanted to point out something. I just wanted to, not more than 2 minutes.
All right.
Yes. That's two aspects which may bear consideration in regard to prospectivity. Is that whether the enactments pursuant to the reference having been answered would hold the field or they are struck down. That is covered, my lords, that the enactments most likely would hold the field because your lordships have acknowledged the right of and the competence of the states to frame the laws. The other aspect is the molding the relief at the behest of whom? The molding the relief your lordships have always done at the behest of the party who has successfully discharged the burden while attacking the legislation. The parties, because there is one aspect in the last order which I wanted a correction. The appellant's word has been used while your lordships pronounce the order. We are the appellants. We are not asking for prospectivity. It is the SSC companies basically.
All right.
Yes. So
That's
therefore,
only a procedural order that we were listing it for today.
yes. So therefore, my lord, the other aspect which I wanted to just highlight, which your lordships have taken note of, is whether the burden has been successfully discharged by them. And then, can they ask for molding of the relief? The other.
If we close it, we'll then.
Lord, can I get, my lord, only 2 minutes by the clock?
I want a minute, my lord, on Odisha.
Yeah.
Lord, I want to.
He has 2 more points. What is the
More
point?
points. The other is the common man effect, which my learned solicitor argued. But the money which comes to the state's coffers are also meant for the common man.
That and what else?
And third, my lords, the power to make laws and power to implement them are also in the domain of the legislature. So if any of the states wants, yes.
Thank you.
And
I only
third,
want
my lords,
to,
All right, let's go.
I only want a minute.
just one order which I wanted to point out, lords, because this is very crucial. The nature of the order which your lordships have passed at the interlocutory stage, and we have this is passed in IA number 3 and 4 in civil appeal number 4745 of 2006, and this is dated 6th of December 2010. This is by a bench comprising the then Chief Justice, Justice Kapadia, Justice Panikar Radhakrishnan, and Justice Satwantra Kumar. May I just read the order? It's a short, very short order. Very short.
What is the date of the order?
The date of the order is 6/12/2010. I can pass on to the Third learned counsel for both sides. We direct that each of the SSCs appearing before us to file returns under the relevant statute. If they have filed the returns, the assessing officer will complete the assessment by a reasoned order in accordance with law. If that order is against the SSE should prefer an appeal in accordance with law. If any matter is pending before the appellate authority in appeal, the appellate authority will decide the matter in accordance with law. It is made clear that pending appeals, every SSE will pay the taxes without prejudice to its rights and contentions in the pending appeals. So these are the nature of orders which your lordships have passed.
Notwithstanding the fact that the law was struck down, there was a direct.
May not be in this group itself, seems to be some other group.
This is from Madhya Pradesh. This is Jay Prakash Associates. No, I'm just showing the nature of interim orders. Either it has been declined or there are positive directions.
There's no such interim order for Jharkhand. That's why I got a little confused.
No, not for Jharkhand.
I only want 1 minute.
The regular bench, not in individual case, they have to take.
We'll have to bring clarity. We are not going to go statewide. We'll pass general direction.
No,
In Jharkhand,
I only wish to say one thing.
There is only one.
What?
Now, Mr. Ansariya, you have
What Mr. Trivedi is saying, for his state relating to mineral bearing areas, that cannot be the rule otherwise. Without Odisha is only mineral bearing. Our act was struck down in 8 months. Not a single demand was raised. There was no levy. I did not collect. I did not pass on. So after 30 years or 20 years, to put this burden today, that I will not take it, pass it on to somebody else who has consumed it. How will this principle apply?
where are you appearing from?
Without for the Odisha industries. We are Odisha industries. There was never a demand. And when the government lost and came to the Supreme Court, there was no stay in the SLP of the state of Odisha. No stay at all. Not below half stay will say. In the case of Odisha, my lord, demand not raised, act struck down in 8 months. No demand, no levy, no pass on. And no stay in Supreme Court. If this be the position, how can, my lord, we be bulked, my lord, with these demands today to be, which we can't recover from anybody. And today, if I pass on to a new consumer, it will be a double whammy for him. Because either the new business.
Yes,
Well, only 2 minutes. Well,
One
it's
sentence
nobody's-
and I'm over. One
that-
sentence. Well, there are 6 matters from Jharkhand High Court, Patna and Jharkhand. 3 decided pre-Keshav Ram, one way. 3 decided post-Keshav Ram, other way. That's all I want.
My lord, only one thing, my lord. The conundrum which Mr. Dwivedi tried to create, my lord, which will be the law which will govern. We are clear, your lordship's 9-judge bench judgment holds the field, India Cement goes. Nobody says that previous to your lordship's judgment, the India Cement ratio should remain. My lord, whether we use the expression prospective overruling or not, we are urging your lordship's 142 powers to mold the relief in peculiar facts of the case, that this is not A versus B litigation, but the result will be felt by each and every common man of the country. So that is why your lordship's power of 142 to mold the relief comes. Lord, so far as this distinction between principal and interest, without again naming the PSU, without interest, one of the major PSU has 35,000 crores without interest, only the principal, and its net worth is 14,000. Net worth is 14,000, and the demand without interest is 35,000. Since it's a listed company, I am not naming the company. I can, my lord, share it with your lordships. My lord, even if your lordships may be persuaded to...
Now the demand of 35,000 crores, how much of it is principal and how much of it is...
Only principal. My lord, with interest it is 55, but only principal without interest is 35,000. Therefore, I gave this figure, that this is not the figure inclusive of the interest. And the total net worth is 14,000. Now, my lord, even if we were to stagger and pass it on to the end consumer, ultimately the end consumer will be burdened, my lord. So we are not saying, my lord, that till your lordships have decided, let India Cement hold the field. That's not the argument. India Cement goes. Your lordship's judgment is the only judgment which is the law of the land. Your lordships can mold the relief that in Calcutta, miners have paid, mineral my lord, bearing land, they have paid. In my lord, UP, they have paid. Odisha, they have not paid. Therefore, my lord, I have said that taking a broader picture, since, my lord, it is a constitutional issue which your lordship settled now, that let there be a pan-India decision that Now, hence, my lord, many a state where the demand, my lord, the act was sustained by the High Court upheld the demand, upheld the law, but the demands were not raised. So there was no payment. Wherever demand was raised, there is a payment. So
Could be the liability. I think it would be difficult for you to answer us offhand. If we take the cutoff as the date of the Kesaram judgment.
my lord,
More-
20 years
No, it is more than 1,50,000 crores from 2004.
for private industries.
I've got figures of a large private company I'm appearing, but I don't want to disclose it now, but it is in excess of 1 lakh crores.
Yes.
My lord, the further difficulty is this. The Lordship has now upheld the power under entry 49, entry 50. Your Lordship has said state has got full power under 49, plenary power. 50 subject to what limitation? Now today from 25th July, Lordships have held in Raya Ramakrishna, tax laws can be retrospective. There's no difficulty. Just envisage different states. Let us not go state by state. Suppose tomorrow every state has endless amount of money. It's insatiable because with the kind of commitment they have. Tomorrow, from 1st August, the state pass a law. You will pay retrospectively from 2020. Somebody will say from 2015. Then again, then
If someone says it-
2004 is also 20 years burden.
But the point is,
Let's not go into the niceties or academic discussion.
we are going to go
2004 is also, my lord, 20 years burden. My lord, and between 2004 to 2024, my lord, there will be several financial transactions which must have taken
more
place.
thing.
What your lordship weighs?
Two of Kesharam. But was it correct for Kesharam to take not that kind of a view to explain 7? Is that another issue?
Okay, should we close it?
See,
now?
PMA 5,
Heard everybody.
11,
No, my lord, just-
5, 7, explaining 11. We have this
But-
problem, my lord, it can never be.
my lord, can I just,
Can't be, my lord, explained by 5.
my lord, can I just suggest two tests, my lord? My lord, can I just suggest two tests, my lord? Yes, my lord, can I just say two tests? Just two tests, yes.
So I think we've now.
Yes, yes. No, my lord, your lordship,
Lordships have
when your lordships are.
142, the,
Right.
your
One last-
lordship's,
last
my lord,
two tests.
desire to do complete justice is the test. My lord, there is no other.
Yeah.
Mr.
Yes.
Yeah, absolutely.
Last two tests, lordship, when your lordships are discussing, please visualize what is the extent of disruption your judgment will cause, because if it goes retrospective. And secondly, will it create liabilities which did not exist on 25/7? In some states there are states, but in most of the states there is no law at all. Except barring couple of states like UP and Rajasthan, my Jharkhand, in most states there is no law.
Like my
And-
state, if there
and
was
my lord,
no
please
law,
don't
Lordship has to visualize, will your lordship
need
judgment?
to pay
One second.
for something when
And-
there
and-
was no law.
Lord, the two tests, Lord,
And-
Mr. comes in.
And please
What
don't
is the
give
test of
states
disruption?
ideas like retrospective legislation.
If the states, if your lordship judgment is going to enable states to create liability, it will be a retrospective liability. So my humble submission is, let it be a binary, or black and white, let it be prospective. Royalty is not a tax from 25/7. Before that, whatever it was,
No,
finished.
we are not on
Getting that,
royalty
yeah.
tax, etc.
Again, you want-
Levies.
Attorney General, do you have a turn of phrase as we rise? Not a submission, but a turn of Attorney General's phrase.
Whatever one may say, we are talking about judicial retroactivity.
No,
And you'll
no.
also have to manage that.
I think we heard everybody.
Grateful.
I don't think anybody will have a feeling that we didn't.
Lord,
Yeah.
All I say,
No,
all I
we
will
never
say
had
is,
that.
please don't give states ideas like retrospective legislation.
The last word which I gave the Attorney General on the bench, I give the last word to my brother Justice HRISHIKESH as usual. before
Yeah,
we
yes,
end.
ma'am, we are also eagerly waiting.
Yes, certainly.
And my lord, one last thing, my lord, the judgments are more difficult to
Lord,
change because
Enough now.
law we can challenge, but a 9-judge judgment we cannot touch at all, many years.
Enough.
This Oak said leave something for, my lord, future, so we can have. But justice, my lord.
What I could understand, very strong battles fought. And the expression used is from this side is that no refund, no demand. It reminds me of a similar war, but in a martial art field. No retreat, no surrender.
Yes. That is balancing equities, my lord.
Very grateful, very grateful,
Please have orders and put down your.
very grateful.